Good morning. You're listening to your hometown station, AM 1220 KHTS. I am attorney Wade Skalsky, and this is Wade Beyond the Courtroom.
It's all about the hum.
That's where law. Yes, I know you pick it up every morning.
I do. It's like just.
Sometimes you psych me out, though. You know what I'm saying? So, good morning.
Good morning to you. How are you?
I'm good. In honor of the beginning of the NFL football season, on the first Sunday, we have switched roles.
I see that.
So I have on a Hawaiian shirt and a some kind of fedora hat, and you have on a black, boring polo.
Now, I like the shirt. Did you? Don't be insulted, but is that one of those warehouse, big warehouse stores that starts with a C?
I actually purchased this shirt on my honeymoon in Hawaii.
Wow!
So this is a legit shirt.
I've got shirts like that too.
I know. So yeah. I don't wear it very often because, for me personally, I can't rock the Hawaiian shirts like you can.
I'm going with the polo today.
I know you look very you look like a lawyer in that thing, man. You look awesome.
I did some background work on Tuesday on a film, and I had to go out Monday night and find some outfits.
Nice.
So I made a quick run to that store in Golden Valley. It starts with a K.
Okay. And
found some shirts on sale. So I'm wearing apartment 19 today.
Nice.
Yeah. So
nice. Apartment 18 was taken.
Yeah.
Okay.
Exactly.
Perfect. So listen, we're going to get right into it. We have a very exciting guest today. The return of the Wade Beyond the Courtroom labor relations consultant, professor, lawyer extraordinaire, law professor Joseph Master Simone. Joe, do I have you?
You have me.
Nice, yes. We had to bring you back and actually prove to you that we could handle the technical difficulties. Yeah. Yes. So, Joe, how are you? How are you, my friend?
I'm well.
For those of
happy first day. Well, it's really not the first day of the football.
First Sunday.
First Sunday of the football.
Yeah, not to get technical on you or anything like that. Just as a lawyer. So I want to since it is football, and I wanted to talk a little bit about Deflategate and sort of. I know you have some strong opinions on it, given the circumstances, and just kind of talk about it. What are some of your first thoughts on it?
Well, my first thought, Wade, I guess, was it's interesting, right? A lot of the football fans, particularly those in New England, sort of celebrated the court's decision overruling the decision of the commissioner to suspend Tom Brady, and it was like, it was unfair how he was being treated this way, and everyone ignores the fact that unless you are Tom Brady or a high-priced football player or in a labor union, most employees in the United States are not, you have no such rights to challenge the unfairness of an employer's decision to suspend or discharge you. Right?
Now,
everyone sort of forgot about that.
Is that because the players and the owners entered into collective bargaining that creates that right?
Right here, that's why they have the right here, because there's a union in place and the players fall under the collective bargaining agreement, and the collective bargaining agreement limits the owners or here the commissioners' discretion to impose discipline or discharge.
Now, and is that because the discipline that we're talking about, or the guideline that Tom Brady violated was, or allegedly violated, was a rule that was in a football game, right? If he had, let's say that if he had violated some discrimination or allegedly discrimination law, then he would have some recourse, right? If it was some sort of grander law that he had to deal with?
Yes, that's right. You're right. If the allegation was that he was being suspended because of, his gender or his national origin, then yes, he'd have a claim under a federal statute. But there's no claim for any employee, absent a collective bargaining agreement, to say I was treated unfairly by my employer and therefore I should get my job back or that suspension should be wiped clean. Right? That just does not exist, because the vast majority of employees work under what we call the employment at will doctrine, and they have essentially no rights to challenge any of those decisions.
Well, and the other thing too is the speed at which this occurred would be pretty unusual. Let's say that even if I did work for a job where I had union protection or whatever, typically grievances to get resolved don't happen that fast in the federal court system, do they?
Oh, no, not at all. And in fact, typically grievances that make it through arbitration, right, and to get an adverse arbitration decision overturned in federal court happens maybe 1 out of 100 times, perhaps. I mean, it's extremely rare and extremely difficult to do, and the system is set up that way. The idea is that the arbitration should be largely final, that the parties have agreed to this method to resolve their differences, and not to go to court, and will only go to court in limited circumstances where there's been some major defect in the arbitrator's decision. And so it's extremely difficult to get an arbitrator's decision overturned unless you are Tom Brady. Brady.
And do you think is it as simple as Tom Brady is married? If you're married to Giselle Bundchen, then you get to get over what you want, But is there some other aspects of this case maybe that actually were it beyond Tom's fame that Tom? I'm on a first name basis with him, Mike. I'm like, oh, Tom and Giselle.
I didn't know you guys were friends.
And my wife, yes, we all do.
We'll have to get him as a guest.
We all have dinner together.
Yeah, okay.
Yes, and talk about everything we have in common with each other.
There are some unique things about this case that set it apart perhaps from other labor relations cases outside of the fact that we're talking about a world-famous athlete. The collective bargaining agreement is strange here in that it gives the commissioner, essentially the employer, right, the right to appoint himself as the arbitrator to decide a case.
I can't even get that to happen in my own home. Like I try to do that in my house, and my wife no, you cannot do that. So I don't know how Goodell got that.
We have to go to break.
So, but it's been in the collective bargaining agreement for a long time. It's not a new provision. It's been in there for quite a while, and it is quite unique. I mean, generally speaking, what would happen in a normal collective bargaining agreement, if there is some dispute that the parties can't resolve themselves, then the case would go to arbitration, and the arbitrator would be some third party, some outside lawyer, or it's their job to be an arbitrator, to be neutral, and to come in and decide the case. But here, the collective bargaining agreement gives the commissioner the option, in his discretion, to appoint himself as the arbitrator, and he did that here. So Goodell acted as the arbitrator in reviewing his initial decision to suspend Tom Brady 4 games.
My thing is this, though, Joe, because it's football, does it change the dynamic? I mean, is there a different set of rules?
It certainly ups the ante, right? I mean, it ups the sort of the public profile of the case. It shouldn't change the rules.
It shouldn't change the rules, but
it shouldn't change the rules.
Well, Joe, let's unpack that a little bit when we come back from break, okay?
Do they get a pass? No pun intended.
Yeah, right, exactly. So you're listening to your hometown station.
I do that all day.
Right. You're listening to your hometown station, AM 1220, KHTS. I'm attorney Wade Skalsky, and this is Wade Beyond the Courtroom. Welcome back. You're listening to your hometown station, AM 1220, KHTS. I am attorney Wade Skalsky, and this is Wade Beyond the Courtroom, where law and culture meet. And today we are meeting with law professor Joseph Master Simone. Joe, do we still have you?
You still have me.
Awesome. Hey. So we're talking about Deflategate. We're talking about how somehow the Players Union allowed Roger Goodell to sort of be the judge, the jury, and the executioner and appoint himself to kind of enforce his own rules and decisions, right?
That's right.
Okay. And do you think that was obviously a mistake in collective bargaining? If the players could have that back, they would. But do you think that they knew that when they did that in terms of to gain something else that they wanted?
Perhaps. I mean, I am not. I'll admit to not being expert in the history of collective bargaining between the NFL Players Association and the NFL owners.
But they're not that dumb, are they? Where they didn't foresee that this was possibly a problem.
It's not a drafting error. I mean, the language is clear as a bell in the contract, and it's been invoked before. And in fact, in the Bounty case, remember a couple of years ago?
I do.
There was the Bounty case that Goodell actually invoked his discretion not to be the arbitrator and appointed third-party arbitrators.
I think that's the hot potato clause in there.
Exactly right. I guess if it's too hot, then he can pass it along. And you would think that this case would have fallen into that category, but I guess it didn't.
Well, politically, he was trying to make up for the Ray Rice debacle, where he had given a really low penalty for Ray Rice, who had domestic violence on his then fiance, his now wife, and I think that's what happened. Is he just had to try to make up the public perception, and it just turned into a total nightmare.
And in fact, I mean, his track record, Goodell's track record of having his suspensions or discipline for things like this, sort of individual player discipline, is pretty abysmal.
I think he's 0-5.
In the Ray Rice situation, he actually tried to then go ahead and put additional discipline after the initial low discipline, right? Mm-hmm. Federal court said, no, you can't do that. That's double jeopardy. You're doing that. You can't punish the individual player twice for the same activity under the collective bargaining agreement. So he lost that case too.
Well, I think he's like 0-5. But
he's like probably I don't know, the Redskins.
Oh. First of all, wow. I'm not sure you can even say that on the radio anymore. I'm going to get some sort of FCC complaint.
You never should have told him you were a fan.
I know. I am a fan of the Redskins. Yes, I love their
I follow the Chiefs here, so who knows? We could be 0-5.
How did the Redskins do last year, by the way?
Not good.
How about the year before?
Not good.
How about 5 years before?
Okay, let's move on. So anyway, let's pivot in kind of the same area, but a different. And this is what I love talking about because the law is so fascinating. Is that okay? So we have the football players on obviously that have the recourse for the courts. So let's pivot a little bit. There was a case involving a college football team that's kind of similar, right?
That's right. It was Northwestern University. And their scholarship football players, about 2 years ago, because the case sort of hung around for a while, attempted to form a labor union and to negotiate and bargain with the school that they play for.
So basically do the same thing that the NFL players have, the same rights.
Right. The same rights and the same abilities to collectively come together and to bargain collectively with the school. The initial decision from the NLRB, from its regional director, who hears cases like this out in Chicago, was that yes, that these players are sufficiently like employees, that they fell under the definition of an employee, and the initial order was that the school had to, or at least that they could have an election, and then they went ahead and voted, and the ballots were never opened. We don't know who won the election or not, because then the case was appealed to Washington. And just a few weeks ago, the board in Washington, the National Labor Relations Board, said, well, we're not going to decide whether they're employees or not, because even if they were employees, we're not going to take jurisdiction over them.
But then there's a second piece of the puzzle here that's really interesting. We're like, okay, maybe I can understand that because they're student athletes and they get scholarships and they're not paid like NFL players. So I can understand that. That seems like that can be defensible. But then there's something else that's about to happen that sort of casts some light on that.
Well, right, yeah. There's another case and this is an issue of graduate teaching students. Graduate student teaching assistants has come up a few times. In the waning months of the Bill Clinton National Labor Relations Board, the board found that those graduate students are employees and could therefore form a union and bargain with the schools that they teach and work at. The Bush board, when it came in, overruled that decision and said, no, they're not really employees. We're going to go back to the traditional rule. And now it seems like the current Obama board is poised to go back to the Clinton rule and say these are employees and they can go ahead and bargain with the university. So I imagine in the next couple of months we're going to have this weird dichotomy, right, where we'll have largely white-collar graduate students who will be considered to be employees under the National Labor Relations Act and can bargain, but football players who are risking lifelong injury every day, generating millions, if not billions of dollars in revenue, will not have those rights. Kind of sad.
Yeah, no, it doesn't make any sense. So basically, you can be a student, and then if you perform a service for the university, then okay, we can treat you as an employee, and you can protect yourselves by unionizing and collectively bargaining. But if you're a student and a football player, well, there's just too much on your plate. You can't handle that, basically.
Well, right, it's not quite that. I mean, the board's decision, the board's decision itself was rare in that it was a 5-0 decision. All 5 members of the board agreed to not take jurisdiction over the Northwestern football players. 2 Republicans and 3 Democrats who probably don't agree on whether the sky is blue.
Right.
All managed to find agreement on this without a single dissent, to find in their discretion that it would not be worthwhile to take jurisdiction over this.
Well,
They had 2 reasons why, largely. One, it was because, well, we can't get jurisdiction over the other schools in the sort of the conference because they're public universities, and the federal law does not apply to state universities and states when they act as employers. And they said, well, so then it doesn't make much sense. That was one reason. And the other reason was, well, the NCAA is here too, and they regulate here, and they have rules that the schools have to follow. And so really, what would they get from bargaining? The problem is the board's been down that road once before. It used to not take jurisdiction over government contractors, based largely on the same theory that, well, the government contract really limits the employer's ability to bargain because it's going to spell out most of the things that they would normally bargain about. So we won't take jurisdiction over that. But the board said, no, we should, and we'll let the people decide whether they want to bargain in this more constrained area. So the board's already sort of rejected that in other contexts. And the idea that we have to get everybody in to a unit in order for it to be appropriate, like all of these players in the conference. The only time the board's ever applied a theory like that is when we're talking about the telephone system or the electrical grid, some sort of public utility. And
hey, Joe, stop right. I got to stop you right there. College football is a public utility. My friend. It is a public. It's for a public good. That's right.
In the meantime, people just want to watch football.
System or not, I don't know.
They just want to watch football.
I don't care about those 19-year-old kids. Just give me some football.
I mean, at the end of the day, are the fans kind of jaded to all this stuff?
They're not even listening to this, man. They're all sitting in front of their TVs yesterday and today.
I would think the Northwestern case probably got more people talking about labor law than anything in a long time, right? It probably was the one time that people were listening, which is, again, odd how the board, in a sense, chickened out a bit and said in its discretion, and we're not even going to decide the case, we're not going to go there. But they're doing a lot of other controversial things that have many people on the employer side upset about it, but that the general person on the street has no idea, and the board is very aggressive in those areas. But this one, which is going to land on the front page of every newspaper, the board holds its hand.
Well, we're going to go to break here in a second, but I think it's when we come back, we'll unpack that some more. But I don't think it's in terms of politics, I don't think it's a red or a blue issue. I think it's a green issue on this, and that's why they punted. So you're listening to your hometown station, AM 1220 KHTS. I am attorney Wade Skalsky, and this is Wade Beyond the Courtroom. Welcome back. You're listening to your hometown station, AM 1220 KHTS. I am attorney Wade Skalsky, and we're speaking with law professor Joseph Mastrosimone. Joseph, are you still there?
I am still here.
Excellent. Yeah, no, we're talking about this Northwestern case where, these 19-year-old kids wanted to unionize, and I'm sure the coaches love that. I wonder who the sort of the ringleaders of that, if they're now relegated to the third string to start?
I think the ringleader was a former player. I can't remember his name off the top of my head. But it was the College Football Players Association they had sort of started. And it was a former player who was the ringleader. So he didn't have to worry about retaliation.
Yeah, I know, but I'm just thinking about
the consequence, right?
Yeah.
I don't mean to cut you off, but the consequence of the board finding them or not deciding the issue whether they're employees and just saying in our discretion we're not going to take jurisdiction is that the players who were attempting to do this, if they're still on the team, could be retaliated against and they would have no recourse.
Yeah, they're like running wind sprints for the rest of their life and never see the field anymore. Yeah,
and they can't they have no legal recourse because they're not technically an employee under the statute, and so the statute doesn't protect them from retaliation.
Well, look, and there's another side of the coin too. Is that the issues with they get scholarships and all of that. That's true, but I think a misperception that people have is everything's they'll just be fine. They'll go to the NFL and they'll make a lot of money. What people don't realize is that the percentage of NCAA athletes that play football that actually ever play in the NFL is infinitesimal. Yeah. And then once they get to the NFL, the average career is like 3.5 years. Sometimes
particularly in football because of the risk of injury.
Right. And the thing is like these kids, like they, obviously they get to play football and it's a privilege and all of that, but I do see that there's so much money being made off of them that some of these kids can't even they don't even have a year. I think they just went to the training table, but I don't think they can do it year round. So, these kids are always training; they're always working out. And
I was looking at some studies last year when this issue first came up at the board, and they were doing surveys of players across various sports about how much time they spend on preparing for their sporting activity, right, versus preparing for class and attending classes. It's not even close. They spend the vast majority of their time preparing for and playing the sport, and limited time actually being a student.
Yeah,
it turns it on its head.
I remember when I was in college, and I would come across a college athlete, and it would be like, "Hey, we're going out. You guys want to come out with us or whatever?" And they'd always be like, "No, we have to go do X." They were always doing something. They're always either.
And I said it wasn't going to the library to read.
Right. They're doing 2-a-days, or my wife was a college swimmer, and so she would tell me about these workouts that she would do, and I would just be like, "Oh, okay, that sounds horrible."
Yeah, and it's not only that too. So I knew a college swimmer who she arrived on campus as a freshman, and she was going. It was time to register for classes, and there was a number of classes she was interested in taking, and I guess her coach got wind of the classes that she was going to take, and the coach was like, "No, you're not taking those classes because those are going to interfere with your training schedule. And instead, here are these online courses that you can take."
So yeah, she didn't even get to participate in
the actual full sort of academic environment at the institute. And this is was a major state university at the state university where she was at, and it's because she was an athlete scholar.
I wonder if folks
not a scholar athlete.
I wonder if folks forget that they are college students. I mean, they are playing football, but there's other also curriculum that
Everybody forgets that. Nobody cares about, like, if you're like an SEC football fan, nobody in the SEC cares about the GPA of their
What do you mean, math test?
or Pac-12. You know, it's the same thing with the Northwestern kids. It's like, I want my football on Saturday, and
I don't want anything to interfere with that.
Exactly. And so that's the only time people care, because it's literally, think about all of the billions of dollars in like food that's bought on Saturdays and Sundays, and restaurants that are gone to watch the games, and the fantasy football and the gambling.
Who's getting that money? Is it going to the college?
It goes to the athletic department.
Okay.
Right. Yeah. And so,
which is sometimes part of the college, but often that money then just goes back into other athletic programs. There's been studies done too to look at whether having a well-known sports program is a sort of financial boon to the university or not. And I think the data shows it's a mixed bag. I mean, the schools do see a spike in admissions or applications if they sort of go to the tournament. And they're given in like maybe into the basketball tournament. But a lot of the revenue that's generated by the sports just go back into the athletics department to build better locker rooms and bigger stadiums and nicer suites for alumni to watch the games in.
Well, listen, as an alumni of
it's not
a
going to the philosophy department.
Right. As an alumni of a Pac-12 school, I need our Arizona football stadium to be improved upon. But anyways, Joe, well, listen, what a great conversation today. You have set a record as the first ever returning guest on Wade Beyond The Courtroom.
There we go.
That's right. So
I'm happy to make it a three-peat if everyone wants.
You're our official labor lawyer.
We could talk all day about this.
Yeah.
This is
we could. I mean, it really is. It's an interesting topic because it intersects law and popular culture.
That's what Wade Beyond the Courtroom does. It's where law and culture meet.
That's the beyond part.
That's right.
That's the beyond part.
That's right. Well, thank you so much, Joe. We really appreciate having you today.
You're welcome.
You've been listening to your hometown station, AM 1220, KHTS. I am attorney Wade Skalsky, and this is Wade Beyond the Courtroom.